Dafeamekpor is an honorable member of Parliament for South Dine.
I've been looking for
Thank you very much for your time and good morning to you.
Good morning to you. Good morning to your viewers. And those who are watching you, I'm sure, on other social media platforms. Good morning to your listeners as well.
Nancy says you are a hard man nowadays to find.
a hagan.
She has abandoned me. She has forsaken and abandoned me.
Well, it's nice to have you on the line this morning, and I'm sure you have been monitoring the discussions on the law the bill you passed. That's on the tribunals. First of all, was the minority part of the process of the passage of that bill?
They were.
They were?
They were part of the Constitutional and Legal Affairs Committee of Parliament that considered the bill as part of the referrals after first reading. You know, as part of the processes of enacting a law or a bill into a law, the bill is first presented, read for the first time, and then it is referred to the relevant committee. In this case, the relevant committee was the Constitutional and Legal Affairs Committee. And so that committee is made up of members of both the NDC caucus and the NPP caucus. They didn't boycott the consideration of the bill. They participated, they contributed, they made informed inputs that were factored into the report that came to plenary for a debate and adoption, which we call the second reading. After second reading, we move to consideration, which is like between the second and third reading. That is what we call enactment. That is when we enact the law. That is where we do delete, amend, delete, amend. They participated. Amendments came from them. Some were adopted, some were voted against. And so on any regular bill, this bill was not different. Now, I want to tell you why there's this orchestrated, well choreographed attempt to bastardize the law. The NPP appears to have a certain phobia for anything tribunal. And so they think that the name tribunal is symptomatic of a PNDC, symbolizes PNDC, means PNDC, represents PNDC. And therefore, it should not have a place in our modern constitutional era. But they've forgotten that the constitution that we all worship is a product of the PNDC. When I tell them, then they flinch, but that's the truth. Now, the tribunal, the kind of tribunal that the PNDC practiced, or the system of tribunal that they practice, they work with, it's not the same as the tribunal that the 1992 Constitution established under its provisions as part of our judicial system. But they won't hear any of it. To the extent that Bimpombuta, the revered Dr. S.Y. Bimpombuta, one of the greatest lawyers we've had in this country, former director of the law school, a very long time text writer, very, very respected lawyer and text writer in terms of constitutional law. In his seminal book on the role of the Supreme Court in our constitutional development, let me refer you to page 28 of that book. He made the point that the tribunals that pertain under the PNDC era from about 82, 83 to about 1989 were not the same as the tribunals that the 1992 Constitution um, formulated and gave birth to. Now, even the procedures are different. Before the tribunals, if you want to practice before the tribunal panel or in any tribunal court established under the Constitution and established again by our Courts Act, the procedure applicable is Act 30. Just like we apply in any criminal proceedings in all our regular courts, from district court to circuit court to the high court, it's Act 30. That's what we apply to any criminal proceedings. But the NPP are on air, alleging that even the procedure, the tribunal procedures are different. So that's number one. Number two, the tribunals have always been part of our regular courts from January 1993 to December 2002. So for 10 years, the tribunals have operated uninterrupted, undisturbed. What happened? When President Kufuor won power in 2000 and was sworn in 2001, they decided as a government that they don't want to hear the name tribunal. So his then Attorney General, Nana Akufo-Addo, who later became President Akufo-Addo, came to Parliament to repeal the tribunal provisions in our Courts Act. If you read our Courts Act, Act 459, it establishes the tribunal system as part of our regular courts with clear jurisdictions to deal with certain offenses and all that. In fact, the Rollins 1, that is in 1993 December, came back to Parliament to actually assign civil jurisdiction to the tribunals, which originally had criminal jurisdictions only. So we had the district tribunals as well as circuit tribunals, which also had civil jurisdiction to hear civil cases. So if we had a land litigation or some civil disagreement or commercial disagreement between you and somebody, you could actually go before the district or the circuit tribunal, depending on the level of or the nature of the disagreement, and have your matter determined. But Nana Akufo-Addo came to Parliament in 2002 to say that they didn't want to have the tribunals to operating any longer as part of our judicial system. So they enacted what we call Act 620, 2002, which is the Court Amendment Act, to take away the circuit tribunals and the district tribunals. Then in the process, re-establish what he called the district courts and the family courts. Because hitherto we had district court, we had them grade 1 and grade 2. But he used that process to review the structure of the district courts and rendered them just as district magistrate courts, simplicity, not grade 1, not grade 2. And also established what he called the family courts. And also established only the circuit courts by taking away the circuit tribunals. So if anybody should be telling Ghanaians why they took away the tribunal courts from our judicial system. It should be the NPP that should be telling us why. And if you ask them why, they are not able to tell you anything apart from linking it to the PNDC.
Mm. And that's the main argument they've made.
Sorry?
That's the argument they've made. It's the argument their flag bearer also makes. History. TUC have also made the same argument.
Now it is actually better to have a court system that had problems than having no court system at all. Now, when President Nkrumah was toppled in February '66, between February '66 after the 24th February coup, and until Buzia was installed sometime '69, bringing in the Second Republic, I should say. Do you know how CPP members were treated in this country? A coup that the NPP, their forebears, that is the UP and the PP, supported. And actually, some of them alive today participated in that regime, in General Ankra's regime. They were key men in that regime, supported them. Do you know how CPP members were treated in this country? They were not taken to court. Nobody sent them to court to even hear their side of the stories. They practiced what we call Protective Custody Act, which was like the twin brother of PDA. You know, they criticized the Preventive Detention Act.
Mm.
Yes. And yet, when they participated in a regime like the SMC1, they arrested CPP people, put them in prisons indefinitely. They were not given any time in court. People like Boy Moses, you need to read about a man called Boy Moses. Boy Moses was one of Nkrumah's special aides, very close to him. He was placed in a cage like an animal and paraded through the streets of Accra. What was his crime? Because he was a close aide of Nkrumah. It was never established that he had corrupted himself in public office. His crime was that he was associated with a man who had founded modern Ghana, got us independence, and just simply got overthrown. So anybody associated with Nkrumah and his political party had to be vilified. And yet the NPP wouldn't let us have peace.
But the question also arises because why do we need the return of the tribunal system?
It is not a return of the tribunal.
I use the word return because you said it operated until, is it 2002?
2002. So I want to use another. I used the word a couple of days ago.
Okay.
I'll get it and I'll use it. We are just bringing back what they took away. Because if you read the reports of the judiciary to Parliament every year, and I know this year they will come during our budget hearing, they tell us that they are inundated with work. The courts are besieged. Every day, the number of cases that pour in, to the extent that even the Supreme Court is complaining that now it's become like a regular court. Because the people are filing writs left, center, right, every day on some matter. So the courts are overburdened. The workload is so big. And they have the statistics to back it. So what they do is that they ask for more budgetary support so they can open more courts. Do you understand what I'm saying?
Yes.
And yet the Constitution mandates us in Article 126 and Article 142 to establish regional tribunals. So is it not better to give effect to those constitutional provisions?
The MPP is of the opinion that the better way to do it is to digitalize the courts, introduce reforms that reduce the burdens on the court, and also, like you were saying, more
Let
courts.
me shoot. I shut down this argument a couple of days ago. So let me do so now. Between 2017 and 2024, the NPP took more than $100 million to modernize our courts, to introduce, to continue with e-justice. Do you know the Honorable Victor Sullivan? Have you ever heard of Honorable Victor Sullivan?
Yes.
Do you know the NPP brought charges of causing financial loss to the state against him?
Yes.
Are you aware?
Yes.
And he was jailed and he died in jail.
Yes.
Even though he became medically unwell, we sought all manner of assistance, they won't agree. Victor died in jail. What was his crime? Victor, as Deputy Minister of Finance, was placed in charge of a project to modernize our courts under Jerome II regime, which was the court modernization project to introduce computerization. Those days, it's not modernization, they use computerization, court computerization project. A man who was working to computerize our courts because judges were writing in longhand and all that, so they just wanted to computerize the courts. They came to power and they found problems for him and they jailed him. Today they took money to continue with a project that began over 30 years ago. Ask them what they've done with the e-justice project. Ask them. The court houses that Nana Akufo-Addo took so much money and said he was building, he couldn't finish. We are now trying to complete. So it is not as simplistic as they want to suggest that we should create more courts or we should build more courts. So the better way to do is to give effect to what the Constitution says we should do. That there shall, if you read Article 142, if you have the Constitution there, open Article 142.1 and read. It's to the effect that there shall be a regional tribunal. Shall, mandatory. So, since Georgina Wood, all the succeeding CJs have refused to give effect to this provision. And I was going to sue. I was contemplating suing, bringing a mandamus application to compel them to establish the regional tribunals. Because one, if you establish the 60 regional tribunals, you are going to create an avenue for other cases to be heard in those courts, in addition to the established high courts, because they have the jurisdiction to hear certain types of criminal cases, which wouldn't have gone to the regular high courts. That's one. Then, if you read our Courts Act, both the Courts Act 459, 1993, as amended by the Courts Act 620, 2002, there's a provision for the establishment of the regional tribunals. That one, they couldn't tinker with it because it's a constitutional provision. Do you understand the point I'm making?
Yeah.
If you don't want a tribunal at the district and circuit levels, why do you leave a tribunal at the regional level? Because it's a constitutional provision. They know that they couldn't have amended the constitution. And yet they refuse to establish them.
And on that matter too, they are of the opinion that the Constitutional Review Committee that President Mahama set up has recommended that you take away even the provision that has to do with the tribunals.
Okay, it's recommendation of a certain committee in the law. A recommendation is what it says it is. A recommendation. It is not the law. When something is recommended, it is subject to approval and implementation. We are yet to accept the recommendation of the constitutional review. In any case, are we implementing constitutional review committee as a country, or we implement acts of parliament as laws? So when it suits them, then they make this wobbly. They want to infest us with this wobbly logic. A constitutional review committee's report is not the law. It's not a law that we can implement. What is implementable is what the Constitution says we should do.
One other issue before I come back to the matter of how this law was passed, they also talk about the fact that you would have lay people who are not trained lawyers like you or judges sitting in
Let me
judgment on criminal
debunk that.
matters.
Again, let me debunk that. If you come to the High Court, our regular High Court, so let me tell you, High Court Accra, the Financial Crimes Division, and somebody is being charged with treason or murder, are you aware that the person will have to be arraigned? We will have to go through what we call arraignment. Hello?
Yes.
Yes, and they will have to constitute what we call the assizes. And when we do the assizes, we constitute a jury. A jury must be constituted. Do you know the people who constitute the jury? They are lay people. Lay people, a jury of 7. They are lay workers, public servants, ordinary people. It is those people that the court will select from a certain pool randomly to constitute the jury to assist the judge to hear the case. If you are accused of having committed treason, a jury will be constituted for you. Haven't you heard that? Have you ever heard about the jury system?
Yes.
The jury system is jurors are ordinary people. What is wrong with NPP people? Because we already have a place in our judicial administration where ordinary people participate. In any case, it is not true that the panel members that will assist the tribunal chairman will be lay people. We can decide that these people will be lawyers. Why? We can. In selecting the panel members, we can decide that they are lawyers, they are trained lawyers. Or people who are even in law school, who are going through training to become lawyers, who have some deep understanding of the law. So they made this argument at the committee level. It was defeated, and that it was baseless because the jury system is already supported by our laws. They came to the floor with it. It was brushed aside as being baseless once more. And yet they are running to the media. They are saying, and some of us are countering them and establishing that it's an argument to nowhere. But because you see, they've gone to meet and decided that they must continue to push these lines of arguments until it festers in the mind of people.
A few questions. One, are decisions of the tribunal system, so if a tribunal makes a decision, is it appealable?
It's appealable.
Okay.
I've been telling them they won't read. When I say this, they get upset. It's the same thing, the same characteristics they exhibited when we passed the legal reform bill into law. They won't read the provisions of the law and they will be making roadside argument. When they say things and you point to them that it is captured in a so and so and so and so provision or section of the law, then they are taken aback. How is that? Why is it that a decision of a district tribunal is not appealable? Under which law would that be possible? How is it that the regional tribunal decision will not be appealable to the Court of Appeal? And yet, they'll come on there and say that it is not appealable. And you see, if you don't have discerning minds listening and questioning the plausibility of that, they swallow it.
And let me conclude with this, because this is about how laws of this nature are passed. The flag bearer of the MPP says the president should not sign the bill into law, not assent to it. There needs to be further consultations on this matter before we proceed any further. Is this how it works? When you're going to pass laws, did you consult enough on this matter before going ahead to pass it?
Let me tell you how this law got here. We are 18 months in office. The 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 promise to bring the tribunals back, reintroduce the tribunal systems, was part of the campaign promise to ensure that the district courts and the zones, the municipalities, and the regional capitals where some of these cases happen and takes forever to be tackled, especially in terms of galamsey, some other environmental offenses, and things like that. When the bill was drafted, stakeholders were engaged. People brought memos. Even when it went before the committee, it came to Parliament, was referred to the committee. A lot of stakeholders who took interest in the bill, they brought memos. So if Baumia is saying that there should be further consultation with whom? Himself?
Yes, himself included. TUC.
Himself included.
Yes.
What is his role in that? As what?
Now he wants to share his opinion on the matter.
But he, as the flag bearer of his political party, he has 87 members in Parliament. What were they doing? 87 members in Parliament who are members of Parliament and who a session belong to the Constitutional and Legal Affairs Committee and said their thoughts. Are their thoughts that they said at the committee level contained in the report that came to plenary, and again they said their concerns and views during the debate before the report was adopted. Are those views markedly markedly different from what Baumia has? In any case, as a government, we cannot wait for him. He has been in this country for all this while. When the drafting began, the community engagement started, concluded, it was brought to Parliament, it made the headlines, the considerations also made the headlines. And he was not bothered until we passed it into law. So he is the flag bearer of the NPP who are minority in Parliament. And they made all the inputs that are relevant in this matter. I mean, you see, these are people who passed the E-levy. Even when the entire nation said no, he was a vice president. They passed it. They told us that E-levy was a panacea to everything. They passed it. So Baumia should know me out of respect. I'll tell him that what he's doing is deliberate. He understands the processes of lawmaking well. He knows that once Parliament has gone through all the gamut of stages of processes and passed the bill into a law, it would have to. If he has to come back to Parliament, he has to go through the constitutional route provided in Article 108. And he knows that it's not possible. But so the call is a mischievous call.
A mischievous call.
Yes, it's a mischievous call. That we should wait for him to make an input. It's very mischievous. He knows that there's no such process under law available to him. But he's making it as a political talk. And so it is to create mischief. And aside that, I think there's also an exhibition of the fact that he has lost touch um, um, with the governance process, because he's not abreast with how things are developing and the rate at which things are moving.
Will the tribunals handle corruption and corruption-related cases?
Absolutely.
Oh,
Absolutely.
I see. Honorable, thank you very much for speaking to us.
It's my pleasure to have spoken with you this morning.
He is the Honorable Member of Parliament for South Dine, Majority Chief Whip, Rockson Nelson Dafeamekpor, join us on the line. And of course, I don't know which question I left out in terms of talking about the process that was followed, and also then talking about why the need to do this and his responses to the main issues being raised by the main opponents. I have brought the new Patriotic Party's comment, the TUC's comments, and he's responding to all of them. What do you think? We have a comment section on Facebook and use. You can also send a comment to 059 and 922 922. This is the Article 142. Establishment and composition of regional tribunals and qualification of chairman and other panel members. Clause 1, there shall be established in each region of Ghana such regional tribunals as the Chief Justice may determine. Clause 2, a regional tribunal shall consist of the Chief Justice, one chairman, and such members who may or may not be lawyers. Such members who may or may not be lawyers. So it is not guaranteed that there will be lay persons. They can decide that they will never use lay persons. As shall be designated by the Chief Justice to sit as panel members of a regional tribunal, and for such period as shall be specified in writing by the Chief Justice. Clause 3. A regional tribunal shall be duly constituted by a panel consisting of the chairman and not less than 2 other panel members. Clause 4. A person shall not be appointed to be a chairman of a regional tribunal unless he is qualified to be appointed a justice of the High Court, which means you're talking about a lawyer who has a certain level of experience. Then Clause 5 says a panel member of a regional tribunal shall be a person of high moral character and proven integrity. High moral character, proven integrity. Those are 2 qualifications that you need to be a judge. You must be a person of high moral character and proven integrity. So that's for the regional tribunal. Nancy.
Awesome. I think that Rockson has come to buttress the points I was making about the Constitutional Review Committee's work. The fact that
it's advice.
Advice. It's an advice.
Yeah, Supreme Court says so.
So when Bawumia raised the issue that because they have said that we should take that part from the Constitution, and so we should wait and pause and blah blah blah, he just confirmed it. That is not law. That is not binding. The government can decide that, okay, this advice I will not take, or I will take. And then we'll take it from there. So that point struck out. Then, you see, I had 4 questions I was going to ask.
Okay.
And when you were speaking to Rockson, he had answered all the questions I have.
All the 4 questions you had.
So, Sana, listen. I asked the question of if we can determine the specific cases that these tribunals will handle.
Okay. I think that was even answered partly by
Adam,
yeah.
How the members will be appointed was one of the things I wanted to find out.
Okay.
Are there safeguards to ensure the independence of the tribunals?
Okay.
Then the 4th question was, will the decisions of the tribunals be appealable?
Okay.
And so he just answered all my questions in the affirmative.
Okay.
It says yes, 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 yes. for others. Okay, so then I don't see why we are having this discussion in the first place. Because Bamia was saying that instead of the tribunals, we should be appointing more judges, improving the court infrastructure. I think he mentioned about digitizing the process and some other things. Okay. Agree.
Yeah.
I agree that all these things must happen
Necessary
to our judicial service.
Yeah.
Okay. But these things coming in, should this stop, or does it mean that we cannot have the tribunals?
Okay.
So now take, for instance, the case of Wontumi. The court that Wontumi has several other cases.
Yeah.
Many cases that they have to look at after his case. See the delay tactics they have been playing back and forth. Today it is one judge saying, I don't want to be part. I'm taking I'm a lawyer, sorry. I don't want to be part of the case again. I'm withdrawing my services. Another lawyer is taking on the case. Now a date has been given. Then they will bring in something else. We are doing that. How would appointing more judges, improving infrastructure, digitizing the process, and all the things that Bamia has mentioned solve this problem?
But will it not? Because if you're thinking about more judges, more courts, it means that the judge that is currently perhaps spending a lot of time on the Wontumi case, you can take some of the cases from him and give to another judge.
Until we get there. What will happen? We should continue this way. And so I think that if all these 4 questions I've listed will be satisfied, I don't see any problem with us
With the
having
tribunal
the
system.
tribunals. Yes. That is what I would say. So,
And for Nicholas Laguda says, I have served as a member of the jury in UK a few years ago as a lay person. That is from Nicholas Laguda.
because the last point you mentioned in the Constitution qualifies him. That the person must be morally upright or something.
Yes.
You mentioned something like that.
Yes.
Yeah. It qualifies him.
Dr. Samson Obedapia says, why are you guys wasting your breath and time on the MPP's position on public tribunals, a political party and the Ghana Bar